My eyesight's getting really bad.
Mine too.
I forget. We decided who's going first?
Peter will. Yes. Well, actually, you will, I suppose.
Is that?
You will, I suppose.
I'm talking about the substance.
But that's why. Yeah,
That's why you're going first.
You're going first.
Yeah, I don't know. Okay, seems like they get a high sign that the web is working.
So that's who. Here you go, 10 a.m. Thursday.
I feel like I'm on high table.
Okay, ladies and gentlemen, why don't we get started? I want to welcome you all to the Woodrow Wilson Center. My name is Jeff DeBelko. I'm fortunate enough to direct the Environmental Change and Security Program here at the center. And on behalf of my colleagues in the Africa program, as well as our Leadership and State Capacity Building program, who joined us in sponsoring today's session, it's a distinct pleasure for us to tackle the issue of land tenure and property policies in East Africa with a special focus on how those issues connect to natural resources and conflict. As a number of you will know, this is a meeting in a series that we've entitled New Horizons at the Nexus of Conflict, Natural Resources, and Health. A series that, as in many programs that we in the Environmental Change and Security Program are doing, are generously supported by USAID. Oh, thank you, Paul. In this case, while it is commonly USAID's Office of Population and Reproductive Health supporting us, in this case it goes beyond that because of the kind of some interesting collaborations within aid, conflict management and mitigation, the biodiversity support team, the Africa Bureau, as well as folks in looking at issues in Asia, are all part of supporting this process and have been terrific partners in formulating this series. So it's terrific to see so many of them here. I do see a few new faces, so you will indulge me to tell you that you are sitting at the Woodrow Wilson Center, the formal memorial to Woodrow Wilson. We are a nonpartisan, non-advocacy forum that brings the worlds of research and scholarship together with a research policy, and then getting the policy and practitioner community together to talk, as this, in many ways, the sponsors of this series illustrate. We have too few opportunities to talk across our different sectoral lines and our areas of focus and our disciplinary backgrounds. So we try to do that here at the Wilson Center. The Environmental Change and Security Program does that specifically in areas of environment, population, development, health, and then in the broader foreign and security policy context, so hence the conflict issues that we have on the table today. I will, before turning to introducing Peter and Greg, tell you that a bit of advanced advertising. The next meeting in this series will be on May 15th, where we'll tackle issues of fisheries and natural resources management, demography, and conflict. And then also one that's not in the series, but I think will be interesting to many folks in this room, on April 28th, so next Monday, Jesse Ribeau from the World Resources Institute and some other folks are going to talk about decentralization and natural resource management, some of the same issues that are very much we're going to discuss today. So I urge you to come for that. Jesse was a former fellow at the center, and so in many ways this is his opportunity to present some of the research that he did while at the Wilson Center. So let's turn, though, to today's program. Peter Hetz, as I think many of you know, is ARD's Vice President for Technical Operations. Peter has had literally decades of experience working particularly in Africa on property rights issues, but really all over the world. He's been a senior manager on many USAID programs, and so knows the agency and U.S. foreign assistance and development policy very well. And so it's terrific that he's joined us today. And as for both speakers, I'll urge you to look at the handouts for the detailed list of their backgrounds. Greg Myers is a Foreign Service Officer at AID. He's the Senior Technical Specialist in Land Tenure and Property Rights and manages the Property Rights and Resource Governance Task Order at AID. So obviously we have the man on these issues from AID really in somebody who has a good sense of how the agency across the board is dealing with these issues in conversation before. He mentioned how it really comes up across the board, and that's part of both an opportunity and a challenge to work with all the colleagues within AID here in Washington and in the field. I think Peter's going to kick us off. We are webcasting this event live, so when it comes to the Q&A time, particularly if you can wait for one of my colleagues to bring you a microphone so you can tell us who you are and put your question into the mic so folks online can hear it as well. So, Peter, please, the floor is yours.
Thank you, Jeff. Good afternoon, ladies and gentlemen. It is a pleasure. I wanted to give you a little bit of context for why you have sort of Mutt and Jeff here in the front of the room. We're oftentimes referred to as...
be careful. Be really careful with the next words that come out of your mouth.
as a team, and we are going to speak today most recently about a series of USAID investments in trying to get to the source, the foundation of conflicts and post-conflicts arising in Eastern Africa, based upon a long-term USAID investment in that part of the African continent. Gregory and I started working together on these issues formally under contract. I represent a contractor. Gregory represents the United States Agency for International Development, and yet we have shared a long passion and interest in property rights regimes in Africa, and it's been a large part of our lives in the continent. And since coming back to the United States, we've taken different, career paths. However, our land tenure and property rights agenda is largely driven by a set of USAID investments that are helping the agency and other practitioners, donors, to better understand the links between land tenure property rights and some of the agencies, or virtually all of the agency's goals, and how they operate within its foreign assistance framework. Towards that end, a series of tools have been developed in support of a land tenure and property rights framework that has been supported by the agency, and it is not our intent to delve into those. But it's those tools and the foundation of USAID's investments that allow us to speak today about specific instances of where access and use issues to resources in Africa, primarily land, are oftentimes the triggers for violence and oftentimes the result of tenure insecurity. And so the title of our presentation today is a bit unusual, and you'll hear about it in the context of the presentation, but we'd like to highlight perhaps the significant drama and heightened emotional content of what property rights for people in northern Uganda, Kenya now, and southern Sudan mean, what these property rights mean to them. So the title of our presentation today is Running with Spears by Their Bellies: Land, Property Rights, Tenure, Insecurity, and Violence in Eastern Africa. On behalf of the Tetra Tech ARD group and behalf of USAID, Greg has asked me to say thank you specifically to the Woodrow Wilson Center, to our colleagues and friends, many of whom with whom we've worked over these past years, for this opportunity to speak. And I'd like to tell you a bit about the flow of today's presentation, what you can expect. I will give a short introduction to the premise that sort of guides today's presentation, some of the key points that we wish to make, and will illustrate using case studies from Kenya to start with, southern Sudan, and northern Uganda, all accumulated within the last year. There will be a summary presented by Gregory, and then we'll be open to questions. Greg will make sure that we don't talk beyond our allotted time. Jeff, if you would be so kind as to make sure that we stay within that time limit. Then we'll invite the plenary here to ask us questions, and we'll try our best to answer those. So without any further ado, let me start by addressing the major issues of our presentation. We submit that insecure land tenure and property rights and the inequitable access to land and natural assets are two of the leading triggers of violent conflict, population displacement, the overexploitation of natural resources, and political instability throughout Eastern Africa. Conflict over the control of land and natural resources is increasingly due in large part to the global competitive demand for Africa's resources and due to the increased value of these assets. As the value in natural assets and their market interests grow, competition will increase, and the absence of transparent, strong, and defensible property rights will erupt in violent competition for the control over these resources, and this will continue or expand further. Climate change, international food insecurity, and global hunger for fuel alternatives from renewable resources will accelerate and augment this crisis. The failure of governments to integrate customary tenure, traditional tenure, into formal frameworks in such a way that customary rights holders can benefit from economic incentives while retaining security of assets and equitable benefits sharing is contributing to the conflict that we witness in this part of the continent. We submit that women and children are amongst the most affected by tenure insecurity and the struggle between formal and informal laws. There's an imbalance between the efforts to achieve an asset security through either formal or informal systems in this context. This is resulting in some highly perverse outcomes, such as an increase in HIV/AIDS infections among women, children, and increasingly large populations of unemployed and unengaged youth make them susceptible targets to conflict brokers. Development assistance programs can actually increase tenure insecurity, from misplacing the location of boreholes, schools, and markets, to large-scale agricultural investments, to titling land in locations where rights overlap and are contested. And you will hear finally that there is a direct correlation between the length of time people have been displaced from their traditional lands and the possibility for land disputes and claims to result in violent conflict as they return home. With the loss of institutional memory, direct ties to land and resource stewardship, and the breakdown of traditional disputes mechanisms, fights over resource access and use, particularly land, can be explosive. Ethnicity, clan relationships, and religion only accelerate this process. Greg and I struggled with how familiar you are with the concepts of tenure and property rights. So let me just establish sort of a common framework, a common denominator for us. When we talk about property rights, we view them in the conventional property rights regime of a bundle of rights, and those we characterize as four primary regimes. Use rights, management and the ability to transform the resource, the ability to transfer rights, and the ability to own. Those are the cornerstones of the rights that we're talking about. The relevant regimes that get kicked around with regards to those four cornerstones are oftentimes referred to as private, common, or public. Then there are issues of open access. And then there's inevitably the struggle between what's called common property versus open access. And what many people, I think, I've encountered regularly disregard the possibility for overlapping regimes of rights occurring simultaneously and over time. We're particularly interested today in the essence of what we call customary rights. And to put those in perspective, I think the most singular contributing factor to my professional interest in this was in joining the Kenyan government in 1976-77 after the establishment of a reserve in northern Kenya that was ostensibly dedicated solely to conservation, but while retaining the use rights of local people towards resources within that reserve. This is now known as the Losai National Reserve. And it was there that it struck me what was meant by overlapping rights, because not only did we have to negotiate for rights around ethnic groups who used this area traditionally, but between patrilineal and matrilineal organizations around these rights, and then the next set up being clan rights within the context of these ethnic groups. You could further distinguish these rights between men and women. Men may have access to one resource, and women may have access to another, and the brokering of those rights access and use issues was often tied to matrilineal and patrilineal systems. What even struck me more was, how do you figure a management plan can accommodate the huge seasonal variety in resource access and use? So take the ethnic, take the seasonal, and then take the gender-based interpretation of rights. And I thought I had it nailed as we started to discuss opportunities for negotiating property rights as part of the management that would support this system. Only to learn that many folks living in marginal areas had, in addition to these contemporary rights, had generational rights to consider. And when we look at overlapping rights, I'm talking about rights through inheritance that can be realized generations later. An IOU that is kept in the pocket and used during times of stress, during times of violence, and during times of displacement. I believe that those four elements of a customary rights regime have got to be appreciated in the context of today's discussion. I'm now going to ask Gregory to speak to two specific examples. He's just returned from a gig on the road for USAID, I think 92 days in the saddle. And he'll be speaking specifically about observations and experiences in Kenya and southern Sudan.
Okay, thank you very much, and I'd like to echo also the same thanks. Thank you for inviting us. Cynthia Brady, wherever you are, I don't know whether to bless you or curse you. But actually, at the end of the day, we really welcome the opportunity to talk about these issues. I don't think we get enough chances to talk about how this really impacts a lot of programming that we do at USAID in a number of our different areas, including economic growth, governance, natural resource management issues, and in health as well. Now, when Peter started, he mentioned that we sometimes like to grab these quotes, that whether they are representational or not representational, we often see quotes from newspapers or from community groups, etc. People say things that add some drama to the story. And so I'm going to present a couple of quotes from both Kenya and my recent trip to Sudan as well, just to give a little bit of flavor. And again, these are meant to just add some flavor there. Whether or not they are representational or not, I will leave it to you to decide. But in Kenya, recently reported in the Standard newspaper on in March of 2008, people in the Rift Valley were saying basically, leave this land or we will drive you out. I think that captures a certain perspective that is a bit inflammatory. So the recent political crisis in Kenya is an example of how insecure land tenure and competition over access to land are drivers in political instability and conflict. Although the recent election violence was cast as one of ethnicity, a significant root of the violence was over insecure land rights, inequitable access to land and capital markets, land grabbing, and poor land administration, such as through the land settlement or colonization schemes. Now, prior to the elections in Kenya, prior to the elections last December in Kenya, land tenure insecurity was already a source of extreme tension and political instability. Many of the grievances over land rights go back to the colonial period. However, many more grievances originate from independence when the government established 3 different tenure systems for ownership of land. One was private or freehold tenure. The second was government tenure, which was largely held under leasehold arrangements. And the third was customary or community land. Through this tenure regime, the government was able to justify taking large areas of trust land under customary tenure and privatizing that land, or the land rights, through the creation of reserves, otherwise known as the settlement schemes, or by selling the trust land off to private commercial interests. The settlement schemes look very much like an internal colonization program. In both cases, for resettlement schemes and for commercial private investment, local communities have rarely been consulted. They've not been involved in the process, they don't know how the process works, and they've been unable to resist or contest these state actions. Although known to be highly adaptable, customary systems in Kenya have been struggling to keep up with some of these changes in the economy and political system. In some instances, because of poor leadership within these customary systems, because of co-option and fragmentation, customary institutions have completely broken down and are unable to resolve disputes, exclude other groups and individuals from over-exploitation of their resources, or resist illegal takings of their land by government and private individuals. Courts and administrative agencies, such as the land offices, the land registries, the county councils, etc., responsible for resolving disputes, resolving contested land claims, and verifying rights, are highly dysfunctional. Simply put, the courts do not work when it comes to land disputes, and people do not trust the administrative bodies responsible for securing or verifying the legitimacy of their rights. Many people simply were forced to abandon land or were forced to take the law into their own hands in resolving disputes. In 2004, the Kibaki government and parliament agreed to appoint something called the Ndungu Commission, which investigated what they were calling illegal and irregular land grants or land concessions. The commission discovered literally thousands of these irregular and illegal grants, reported on them, and found that included in those illegal and irregular land grants, there were many to past presidents, Kenyatta and Moi, the current standing president, Kibaki, and also to the man who would become the new Prime Minister, Odinga. Many of the land grants were given out to patrons of the political elite. The Ndungu Commission made recommendations for the appointment of a judicial body to take back or to buy back illegal and irregularly granted land concessions. This commission and past reports to government on land grabbing and problems related to insecure land tenure was largely ignored by the government. Prior to the December elections, non-Kikuyu Kenyans across the country were angry, marginalized, and hoping that the elections would address land-related grievances, while Kikuyus were concerned that a change in government would result in them losing land. Many of these Kikuyu concerns came from smallholders who had legitimate claims to land, who had either bought these parcels or had been resettled by the government in resettlement schemes. And of course, importantly, some of the concerns were from a small elite group of Kikuyu and other leaders whose land holdings would have been threatened by a change in the government. Institutional failures and the inability to address past grievances all came to a boiling point again in December of 2007 after the election results were announced. And many Kenyans felt that business as usual would continue. This resulted, as you know, from watching the news services and mass political demonstrations, violence, and displacement, and in a very real way brought Kenya to the verge of open civil war. The disputes over land were and are not just in the Rift Valley or Western provinces, as widely reported in the news, but are widespread across the country, occurring in all 8 provinces. In recent interviews in Central and Coast provinces, respondents stated that if land issues were not addressed soon, violence was likely to erupt again in these provinces, as well as continue in the Rift Valley and Western provinces. The most recent crisis after the election led to many people being killed and displaced more than 500,000 people. At least 300,000 of these are which are currently in refugee camps. This does not include the many thousands of people displaced following the past elections and crises. These individuals, too, are looking for resolution of their land claims. Ethnic regionalism and nativism are now defining the post-election crisis, with Luo in the Rift Valley and Western provinces telling Kikuyu that their land is in the Central Province and to, quote, get out, don't come back, or we will kill you. And Kikuyu telling Luyas, and Kalenjins to leave central Kenya. This has the potential for, at the very least, larger numbers of displaced people, reducing agricultural production and investment, and at the very worst, additional killings and political instability in Kenya. The government of Kenya, perhaps aided by misguided international concern over food security and humanitarian conditions in the refugee camps, is overly focused on resettlement and moving people out of the camps as quickly as possible, rather than addressing the root causes of displacement. This is a recipe for disaster. A methodology for relocation. Who should be relocated where, on whose land, and under what circumstances is critical. In the absence of such a strategy, and under pressure to move people out of the refugee camps, IDPs may very well be put in dangerous conditions where they could be killed or could become the triggers for new rounds of violence, as happened following the last 2 elections in Kenya. A strategy must also be developed to address land and assets that were stolen from IDPs by local residents. To resettle people without addressing this issue sets a very bad legal precedent in Kenya. At the end of the day, the real losers in Kenya, in Kenya's land tenure and property rights problems, and in the past crises, are women. Women, who make up more than 50% of the agricultural workforce, are very much dependent on access to land, which is not easily secured directly through customary or statutory law, and particularly on secondary property rights, such as for subleasing agricultural land, for access rights for collecting wood, plants, fruits, and for grazing sheep and goats. Women will have an increasingly difficult challenge to reaccess those rights when they attempt to resettle in Kenya. Now, turning quickly to southern Sudan, I would like to make some similar observations and start with a few interesting quotes as well. This 90 days, I spent a fair amount of time in southern Sudan and Kenya during that period of time, and had a chance to talk to a number of different groups, people affected by the conflicts in both countries. And I'd like to share with you 3 quotes from southern Sudan. One of the quotes was a statement made to me in February of 2008 by a traditional leadership council. And this traditional leadership council said, and I quote, "We are developing hatred for this new government, the government of southern Sudan." In a blog that was posted in March of 2008, somebody said specifically, "We will drive the Dinka out of the Juba area by any means necessary." A third quote I'd like to share again from February, and this comes from Bari traditional leaders in and around Juba, who stated, "We don't want the government of southern Sudan here. They are giving away our land." So, land tenure security is intrinsically connected to political, social, and cultural identity in southern Sudan, and the conflict over land is symptomatic of the greater regional struggle for control over the south. As a result, land tenure and property rights is a key component of the Comprehensive Peace Agreement, the CPA, and is also a key component in the interim constitution for southern Sudan. The CPA mandated that the development of a land commission to help address land tenure-related issues and foster the development of land policy and intergovernmental coordination. Nevertheless, land tenure and property rights remains highly political and sensitive in southern Sudan, and land-related disputes could easily contribute to, or be the trigger in, violent conflict between groups or states in southern Sudan. Complications over land access and tenure insecurity are more contentious in areas where there are numerous overlapping and competing land claims. Overlapping claims are a result of historical rights and competition, for example, between agricultural and pastoral groups, and between ethnic groups, as a result of displacement and post-war IDP refugee movement and return or attempts to return, and where there are competing claims over natural resources, such as for agriculture, grazing, or for mineral exploitation. Increasingly, there are also overlapping claims resulting from the expansion of urban areas, for example, in and around Juba, and agro-pastoral peri-urban areas. The greater the diversity of ethnic identity that exists in a geographic area, the more pressing the land issue becomes in maintaining peace and stability. The government of Southern Sudan has not yet been able to establish a land policy or land law. As I stated, a land commission has been established, but it lacks technical staff to develop policy or law, or to coordinate a broad-based discussion on land tenure-related issues for Southern Sudanese. Government institutions in Southern Sudan are extremely weak, and in the area of land tenure administration, they are even weaker. The government of Southern Sudan has not yet established clear institutional and administrative lines of authority. In short, it's not clear which administrative body, ministry, agency, if any, has responsibility for developing land tenure and property rights policies, laws, administrative rules, and then implementing them. In the interim, different levels of government, state, county, and national, are competing with each other over who has the right to distribute land in various areas of the country, and specifically in Juba, the new capital for Southern Sudan, and other regional state government areas. And what I think is a very recent, interesting example in East Equatoria State, where the capital is located, there was recently announced that the state government, okay, there's federal government, state government, it's a little bit like Washington, D.C., federal government, state government, local government. So in East Equatoria, the state government announced that the state would give out the property rights to up to 1 million parcels of land in and around Juba to citizens who wanted land. This is an area that is already highly populated by IDPs, and it's also home to a local Bari community group. The Land Commission, again a body appointed by the national government and mandated by the CPA, announced a few days later that the state government had no authority to do this. Following that, a few days later, the state government responded that it did have the authority to do so and promised people that it would move ahead with its commitment to grant rights to land, and once again encouraged people to submit claims to the Land Commission. This, as far as I know, has not been resolved. It is not clear where this land would come from, or if either the GOS, the government of Southern Sudan, or the state government has the authority to give out land rights under existing legislation. At the same time, Bari traditional leaders in Juba have complained that they have not been consulted and that they will resist, their words, any attempts to distribute land to, by, or for the government of Southern Sudan. This debate between traditional leaders, state government, and the government of Southern Sudan has taken on ethnic dimensions, and this is very worrisome. In this confusion over who has the rights to administer land, private individuals and groups have been able to grab access to land and or displace weaker individuals and groups. This grabbing, too, has a definite ethnic dimension and could undermine political cohesion in Southern Sudan or pit ethnic groups against ethnic groups which together have previously fought hard to create a new state. This, of course, could lead to widespread violence, killing, and population displacement. Okay, now I think Peter's going to talk a little bit about our experience or our research in northern Uganda.
Thank you, Gregory. 3 case studies, most of these revolving around land, but land that hosts opportunities for subsurface property rights, minerals, and surface rights, as well as water rights, fishing rights, etc. It's ironic, but we know about rights being manipulated or lost in large part around civil war, where people perpetuate violence, maintain conflict because it gives an elite group of people access to resources that they can turn around and use in support of that armed struggle. That is reflected perhaps at one end of the spectrum, most notably within the realm of conflict diamonds, but it's been related to issues of timber, related to issues of oil, which are vitally affecting the U.S. economy present day in southern Nigeria, and are related to other mineral extractions where an international market will force people into more desperate and immediate ways of extracting those, casting aside anything that resembles statutory, let alone customary property rights. The irony of the northern Uganda situation is that after decades of being displaced in the face of a conflict that is largely based upon ethnic lines, displacement of more than 2 million people offered a major part of northern Uganda an opportunity around natural resource rights. And by those I mean because people who were forced into camps and maintained in camps in some instances in excess of 20 years, there has been significant regeneration of woody biomass in northern Uganda, representing an opportunity for sustainable natural resources management as well as biodiversity conservation. My talk on northern Uganda will try and emphasize what lessons we are learning from northern Uganda and how these relate to our property rights regimes. Now, in all of these instances, I don't mean to blithely cast this great blanket over geographical areas and call everybody the same. And I want to nuance the fact that northern Uganda is a complex grouping of ethnic groups and has historically been transient, and the most recent establishment of ethnic groups in the north that have been affected by the war are largely characterized as people called the Acholi, the Lango, and the Teso. And each group has been displaced for various periods of time from their original homesteads. These three major ethnic groups form major ethnic-based regions in the north, and each have been affected by the fight between the Ugandan People's Defense Forces and the Lord's Resistance Army, in some instances for more than 20 years. That's a generation. As of March 2008, only 9% of the Acholi people have literally returned home, back to their homesteads. More than 32% are in transit camps, halfway homes, over which they have no legitimate rights. And the rest remain in original IDP camps, some 59%. And it's about these people that I will be speaking today. Despite the numerous lessons that we've learned from post-conflict resettlement and property rights in Africa, the national policy for peace, recovery, and development for northern Uganda, published by the Ugandan government, still demonstrates a fundamental disregard for the importance and urgency associated with land tenure and property rights. It is barely addressed. So a major policy guideline and donor investment document still fundamentally disregards these basic rights. This is nowhere more apparent than in northern Uganda, and particularly in the Acholi sub-region, where historical differences between the forces of the president, who took over power in the middle 80s, and the North, who were traditionally aligned with the people who were thrown out of power, remain vital in terms of conflict. With the prospects for peace always months away, there is an opportunity still for us to position a proactive strategy that helps resettlement on the land, and an opportunity to nurture a regional program of secure, enforceable property rights. But this opportunity, I'm concerned, this door of opportunity will close in the melee, in the rush to return home, for people to occupy land and to acquire or reacquire traditional rights, access and use rights to resources. The results of missing this opportunity could be a painful and protracted period of failed and inequitable agricultural development, resource allocation and benefit sharing. Could be the source of significant and, I have to say, continued corruption. It will fuel cross-border disputes. It will support huge unemployment, crime, and continued regional instability. The political leadership amongst the Acholi remains widely divided between customary and statutory lines. Many of you know that Uganda has developed a sophisticated program of decentralization and district-focused development that is running in parallel with a strong Acholi tradition of customary governance. After 20 years of armed conflict, traditional community, clan-based systems, social welfare, and dispute resolution mechanisms have, oddly enough, deteriorated after 20 years living away from your power base, your land. This leaves a dramatic and disturbing power vacuum amongst the Acholi people that is rapidly being filled by political and civil government authorities, including the armed forces. The potential for disputes and conflict between these power structures is more poignant than ever. The most determined and resounding call amongst the Acholi remains the desire to return home. I just don't, whatever you say, I just want to go home. Any discussions or programming on land that delays this move will be regarded with suspicion and distrust. And indeed, the sort of go slow approach, let us get out in front and let us work with you in order to determine who has what rights and actually begin to look at mapping or looking at a rights registration, all of that. If that delays me going home once that peace accord is signed, stay out of my way. And while discussions concerning the environment and the opportunities to capitalize on the environment and sustainable natural resources are considered important by all Acholi people, folks do not commit environmental suicide intentionally, believe me. The most significant priorities still remain: I need to get back home, I need to get access to my land, I need to build a house, and I need your assistance to start up with agriculture. You can talk to me about elephant migration corridors. You can talk to me about alternative fuel wood. You can talk to me about biomass production. That's all very well and good. Let me get home. Greg and I had an opportunity to speak with a wide variety of people in political camp situations and amongst the Acholi leadership in March of 2007. More than 1,000 people, I guess, were actually surveyed. And they acknowledged that there would be disputes and conflicts over land. It's not unnatural to expect that. Most people considered this to be an inevitable product of displacement and correlated the number and intensity of land disputes to the amount of time they'd spent in camps. The longer I'd spent in camps, the harder it's going to be to get home. Hence, certain districts of the Acholi group could be expected to suffer more land disputes than others who had been displaced for shorter periods of time. In this gathering of political and customary leadership elites, they were able to characterize potential land disputes very sophisticatedly at different levels. They would deal with property rights disputes around household and intra-clan disputes. Hardly surprising. We do it every day if you've ever had a fight with your neighbor over a fence line. Inter-clan land disputes, where townships, where I come from is provincial Vermont, and provincial Vermont has little battles over township borders and who has access to water coming through that township. There will be land disputes based on inter-ethnic clashes over land and natural resources. The Acholi and other groups around them. Some of you may know of a very significant armed pastoralist group in the northeast of Uganda called the Karamojong, who periodically raid the Acholi. And then there will be land disputes with the government of Uganda over land whose title or leases are unclear and are problematic. And then the fifth one is that there will definitely be disputes over property rights related to natural resources and public lands. Hardly surprising. We don't want to go back and find that the forest reserve and the park and the game reserve and the government ranches are still intact and will still be excluded. We want to take this opportunity to redefine our access and use rights to public lands. Starts to get scary. The legal and regulatory framework guiding the resettlement and lands rights have yet to be interpreted successfully within a customary system there. It's patrilineal, patrilocal, which means the guys are in control and the gals move to the guy's family, and they basically become property thereof, many of the women. And while the Constitution and new land law make provisions for customary certification of land, sort of a very proactive approach taken by the Ugandan government in its land policy and land legislation, to date there's no experience with actually how you grapple with customary land rights registration, customary land tenure systems. Customary law and customary land tenure systems have yet to be successfully integrated into the land policy and land law. The absence of guidelines and experience in this respect leaves the land law open to a variety of interpretations, which are being capitalized on, and they continue to lead to confusion. This confusion is beginning to fuel unnecessary conflicts and disputes. Well-intentioned efforts to support customary land certification in the North could, without the proper measures, the proper engagement, fuel conflicts between clans and civil authorities. And hence, they will run with spears by their bellies. One paramount chief in the Acholi system stood up at the workshop and said, "If anybody messes with my clan land claims, I can mobilize 700 warriors, and they will, in the Acholi tradition, run with spears and shields, spears by their bellies, meaning that phalanx approach of 700 armed warriors coming down the path and taking on anybody who dared to contest their clan-based claims." Right now, land redistribution is not so much an issue, as there appears to be plentiful land. If anybody has ever traveled up to northern Uganda, it's the classic, the old colonial adage was miles and miles of bloody Africa. Nonsense. It looks like wide open, quote-unquote, unused land, but there is no such thing in Africa. There are claims and property rights that have been registered with people for thousands of years. And those claims are very, very much vital. And there are people who are interested in manipulating those claims, both contemporarily as well as historically. The plentiful land looks like it's plentiful, but the Acholi population, for example, has increased by at least 100% over the last 20 years. So you have a doubling of the population and an entire generation which has had no significant links to those lands. While it has been publicly stated that everyone can return to the area from which they were displaced, it's still unclear if legitimate claims to land and the resources on them can be accommodated within the traditional clan land allocation and tenure system, and the ability or the inability and failure to redistribute land in the face of growing population needs could present an additional set of conflicts. This is further complicated by the number of people who have the potential to be disenfranchised in this post-conflict land access and distribution issue. Vulnerable groups, in particular after armed conflict, include female-headed households, no longer having households defined by men, widows, child mothers, HIV/AIDS victims, children in large part who have been abducted and grown up away from home, people who are returning from outside of the country, and illegitimate children. How significant is that? Well, in the northern parts of Uganda, particularly in the Acholi area, it's significant. For women in these groups, customary law protects them, but only up to a point. The Acholi are both, as I said earlier, patrilineal and patrilocal. Thus, when daughters marry, they move to the husband's home and become part of his clan. Land is passed down to males only. Thus, neither widows nor daughters have ownership rights to land, only use rights under customary law. You can use it, but you can't own it. You can't transfer it. You can't. Many women have children but no husband, and then do not have the customary rights to any land because they have left their clan and they have not been taken in by the clan of the father of their children, either because they never got married or they can't recognize who the father is. And as well, many children cannot trace their father and therefore have no customary rights to land. So you have a huge population of kids who can't legitimately go forth and make any legitimate land claims in a customary system. It's thought between 10 and 15% of the population of the North is disabled because of the war. Disabilities include those that have occurred because of the war, landmines, increased prevalence of diseases and mental illness, and those that would otherwise exist. Physical disabilities make it difficult or impossible to farm, to get water or fuel, and to be otherwise mobile. While in the camps, many of the needs of the displaced and disabled have been taken care of by humanitarian assistance. Upon return to rural areas, however, these services will not be available. Many disabled people will not be able to farm their land as an asset, nor will they be able to lease it out or sell it, which would provide them with the means to earn a living in another way. Just when you thought it was getting bad, it gets worse. 50% of the populations in camps are believed to be infected with HIV/AIDS. AIDS is still stigmatized, and many of those infected are unwilling to tell their partners for fear of being abandoned, increasing the likelihood that the infection will spread. The IDP camps are relatively closer to town centers and near medical facilities. When IDPs return home, there will be very limited medical facilities. Those who are ill and unable to work are unlikely to receive land in the initial distribution. Those who are women or orphans are even less likely to receive land, given the discussions mentioned earlier. Land is a critical asset for those with HIV/AIDS because land and housing and other property constitute a resource base upon which the household can draw to cover HIV/AIDS related costs, including the costs of medical treatment, the provision of care, and services related to deaths and funerals. Land may also, and natural resources may also, provide the means of sustaining livelihoods even when the income earned is through the leasing out of land. Profits from the sale of assets can help offset losses that result when household caregivers, often women and girls, are diverted from other income-generating activities. One of the biggest needs expressed by people in the North was the importance of public information and awareness around resettlement. Campaigns focused on knowing your rights and responsibilities with regards to land, resource management opportunities, resource access, and use. They didn't need to be told that by outsiders. It was a clearly expressed need. They believed that this effort could make a most beneficial input into the dialogue on land issues and resource issues in the North. And in its absence, people will suffer from continued efforts of regular information manipulation and disinformation campaigns. Greg and I both witnessed a large tract of land that has been manipulated by elites associated with the Ugandan People's Defense Forces in a critical area for natural resources management and biodiversity conservation, opening up large tracts of land for agricultural purposes. That's tolerated because people stay in camps and don't know what's happening. It's supported because the revenue that's generated from that is lining people's pockets. A truckload of cassava goes for between 4 and 8 times the market rate in Uganda in southern Sudan. A bag of charcoal in northern Uganda is 8 times its price in Uganda in southern Sudan. There are market incentives to do everything wrong in looking at tenure and property rights, land use, and sustainable natural resources management. Northern Uganda faces a significant challenge not only in its own internal recognition of tenure and property rights, but is looking at how those get secured in the context of significant regional market demand, where people have a ready need and are willing to buy those resources.
Okay, so having overwhelmed you with all those statistics, especially the one which I find the most alarming is the rates of HIV infection rates in these camps. We have a few takeaway messages that I think we'll then be able to use as departure points for discussion. Almost 50% of African states return to war within 10 years. War in Africa is too often a symptom of a fundamental problem with land tenure and property rights, including issues related to competition between statutory and customary systems, inheritance, land use by one minority at the expense of a majority, unclear or unendorsed rules for natural resource access, the manipulation of large areas of land by state authorities, corruption, conflicting economic and governance objectives, and the repeated disenfranchisement of the losers and or vulnerable groups following the conflict. All of this we see in the three examples that Peter and I just illustrated. Secondary post-conflict conflict over land, natural resource access and use, and housing often erupt as people leave camps and start for home. Conflicts involve IDPs, landless, and demobilized soldiers. This is a repeated theme that we have seen in Mozambique, Angola, Rwanda, Burundi, which has just re-erupted, Sudan, Kenya, northern Uganda, and Liberia, among others. There are often competing messages and objectives given by donors in the international community over resettlement post-conflict situations, and frequently a misunderstanding of the role of land tenure and property rights as triggers or drivers in conflict as humanitarian organizations push people to resettle as quickly as possible. In many cases, people cannot go back to where they came from, even if you can agree on where they came from. We need to refine our foreign assistance programs to better link our various goals, such as those for humanitarian assistance, displacement, and land tenure security. We need to think carefully about the appropriate sequence of interventions in property rights and reforms during and after the conflict. We need to focus on land tenure and property rights issues during the conflict and not wait until after people have already left or are trying to leave the camps. We need to look closely at the differentiated impacts on men and women and on vulnerable groups. Women may have no place to go, particularly if they are infected with HIV/AIDS or if they've been raped, if they have children and are unable or unwilling to identify the fathers. We need to consider such things as land banks, land tenure reforms, or land trusts dedicated solely to the needs of women and vulnerable groups as a means to acquire access to assets and generate income. We need to consider establishing an informal but formalized system of registering legitimate land claims where customary systems still are recognized and supported. And this could happen still while the conflict is ongoing. This would not be an official registry or a cadastre, but it would serve as a written record that can serve as a focal point for further rights registrations, dispute resolutions, and claims security or legitimacy once the dust actually settles. We need greater public information and awareness. And we need to use this as a primary tool for helping people in post-conflict settings to understand their land rights, their land and natural resource rights and responsibilities in post-conflict settings. Only informed people can make informed judgments in support of peace, good governance, and the rule of law. We need to think about supporting programs and reforms that adapt customary systems rather than replace them with statutory rules. While the latter may seem a lot cleaner and easier, it is often a recipe for disaster. Customary is not static, and it is not a romantic situation. Customary systems are an alternative to formality. They are often cheaper to administer and often have local legitimacy, but they may need some tinkering or social engineering, such as around inheritance, collateral, individual rights within groups, and particularly for women's rights. We must support legal and institutional reforms that give the most people the greatest number of opportunities to access resources and secure their rights. With that, I would like to thank you all very much for listening to us today, and we would like to offer you the opportunity to ask us questions now.
Terrific. Thank you very much. Oh, Peter and Greg, you really have given us a tour de force in terms of trying to understand Kenya, Southern Sudan, and Uganda, and how the land tenure and land property rights are really critical to understanding what's going on. And we try at the Wilson Center to really bring in reflection on critical issues and not just chase headlines. But in this case, we're bringing that long-term reflection on these issues, and they just happen to be also the issues that are the subject of above-the-fold headline. So it makes it all the more appropriate that we have the longer view and the really on-the-ground perspective from all your consultations. So let's turn the floor over for a discussion now. As I mentioned, we'd like to have you share your question with a microphone so the folks online can hear them as well. We do have a lot of folks here today, so I think we will probably take a few questions, groups of questions, and then have Peter and Greg divide and conquer in terms of responding to them. So why don't we start by getting 2 or 3 or 4 questions together, and then we'll go from there. So why don't we start, gentlemen in the back. Sonia, if you could hand the microphone. If you could let us know who you are as well. Thank you.
I'm Vemba Dizolele. I'm with Good Works International. I'm Congolese by birth and by identity as well. My question really to you, thank you. First of all, I want to say thank you for the thorough presentation you just made. But the point I feel that has been missing in all this is the role of ethnic identity. I think Westerners often look at the land issue in the abstract. As an American citizen, I can get up here and move to Arizona. And I don't give second thought who Arizona belongs to, because the Indians at this point are pretty much irrelevant in this picture. In African culture, it doesn't work like that. So is there a role for ethnic democracy? And by that I mean land in Africa belongs to a specific group. It's not an abstract legal term in the way Westerners define it. If we were to revert to traditional law, where people in various regions, through the governorships or local chiefs, will determine who the land belongs to, will probably solve a lot of the problem. And also I think we should not be thinking about it during the war or after war, but before that happens. We see this in Spain. We have Catalonia, we have Galicia. These are ethnic groups who have fought for determination and the right to their lands. I'll leave it there. I think you get my point. Thank you.
Terrific. Antonio, if you go just right in front, the gentleman right there.
Yeah. Chachim Beseta Menon. The land tenure and property right issue are a domestic issue, and how the AID proceed is, and does AID fund the person or contract go there, or you have a AID personnel involved? And does the government, intergovernment negotiate first and then proceed? And second is as to funding. For example, here mentioned Asia Development Bank. I think this for Asian. And so just use the Asian example, how this Asian Development Bank and AID coordinate the funding or cooperate that, and how you do it. And third, should the land tenure and property right consider as a human right issue? And third is, last one is, forgive my ignorance. I don't know what's AID, and maybe you should tell us more about AID, and so we can have something appreciate or judgment about your activity. Thank you.
Okay. Well, we have quite a few there. Why don't we start with those two-persons sets of questions there.
Do you want to start with the first, and I'll add to it, or shall I start with the first?
No, since you've got all the aid questions to answer in number 2, let's turn off. Ethnic democracy, the concept that you mentioned. We can't obviously divorce ourselves from the historical context in which Africa has emerged as a continent. And you're right that there is a very abstract and ideal sense of what Africa land issues are. And they are driven by ethnic identity. And clearly, ethnicity and identity around land, but not just land, other resources, has been a critical part of self-definition. That self-definition is still very active, and I think that despite the efforts to move Africa, in both the colonial and post-colonial regimes, towards the freehold land ownership concept, it's been increasingly demonstrated that is more and more difficult and less likely to succeed in a spectrum or in a framework of where people are not prepared to jump from customary identity and ownership rights to individual privately held rights, where they can take those to a bank and transact them on the basis of collateral as loan. I think in large part a lot of the problems that we've talked about today stem from this disconnection and disregard for customary rights, and an inability to pay attention and listen to and negotiate and broker what these rights mean in an emerging nation state, in an emerging market economy, and how the collective benefits derived from customarily or communally held lands will be redistributed to people and make a difference. Will you eventually see people moving from one area to the next? I believe that that is what Kenya thought it was doing. I believe that that's what Kenya thinks it was doing by its land reform efforts and allowing people from one ethnicity to move and occupy land in other ethnicities and other ethnic areas. We saw that absolutely explode in our face in post-election because it was an issue that had never been fundamentally dealt with, and it was the fact that those rights were never transparently transacted for the most part. They were held by a few elite, dispensed by a few elite, grabbed by people who were legitimately looking for a piece of land to live on because there was no longer any room back home, only to find that those are false rights. They were never, ever negotiated properly within the context of where they moved to. So that in short is my response. I don't see the question of ethnicity and people jumping into new areas being solved readily. I think people still see that fundamental identity with land and the resource base upon which they were born and their connection to it.
I would like to add to that before I move on to the USAID questions. In the case of Kenya and many other countries, you have to think about, is this a market-based economy? Do you want a market-based economy? And if so, then you have to have a situation, or you have to have a legal situation that encourages people to be able to move anywhere in the country that they want to move. If you're saying that only Kikuyu can own land in historical Kikuyu areas, and that would be a very hard thing to define, what is a historical Kikuyu area. If you only want people to own land in that area, then you create laws or you create procedures or administrative rules that restrict people from being able to buy land in other parts of the country. And I don't think that's a good way to develop an economy anywhere in the world. So I would not recommend doing something like that. The second point I would make is this begins to verge on a discussion about sequencing. And when we look at land tenure and property rights issues in terms of the way we assess them, the way we understand them, and the way we intervene in these issues, we constantly are thinking about what is the most appropriate sequence of steps in a given situation. Now, of course, that sequence of events is going to be different in a conflict or a post-conflict situation, as the cases that we've just mentioned to you, as it might be in another country where we're not just coming out of a conflict situation. But the sequence of events or the sequence of reform measures is very critical and important. In many cases, what you want to do is you want to try to create an environment in which people have, and this goes to the last statement that I made, that they have the most options available to them. So in some instances, people will use customary institutions and rules, traditional leadership as you refer to be able to secure their property rights and their access to natural resources and assets. But frequently, people will also look for opportunities to be able to formalize those rights. In the case of Kenya, in very interesting and complex and nuanced ways, you had some communities who were trying to do both at the same time, basically trying to hedge their bets against the threat of other groups that they couldn't exclude, as well as the threat from the state. So you have people saying, if we can register our land, if we can get land title to our land, even if it's a community-based land, and then we will use customary rules and regulations to define within that broader area how individuals or households or families get access to the land, how we resolve disputes, etc. That's what we'll use. So in those instances, people are trying to use both statutory and customary law. I think in many places in Africa, what you see is this movement from traditional or customary rules and regulations more toward greater formality. But where it works best is where people have opportunities to jump back and forth if necessary. The last thing I want to say is, on this topic, I would not want to romanticize traditional leadership. Traditional leaders can be a big part of the problem. Sometimes they are either co-opted or they are so badly undermined in case of conflict that they are unable to assert what I would call customary rules and norms. And in those cases, those communities are actually in a worse situation than they were than they were before the conflict started. So I am very reticent about lending a certain sense of romanticism to traditional leadership, and would be very skeptical about any statement that would say, let's just return to traditional leaders because they have a better way, or it's a better management style for determining who gains access to which resources, etc. Now, with regard to the questions about USAID, that's a very broad and big set of questions. I will not try to answer the broad question about the range of issues or the range of areas that USAID intervenes or involves itself in around the world. I'll just restrict my comments to specifically this set of issues. USAID has made investments for a number of years, actually going back to the founding of the organization in the 1960s, to look at land tenure and property rights issues. Initially, these were largely focused in Latin America, but now they are focused globally. And we do work on land tenure and property rights worldwide. At my last count, I was able to estimate that there were approximately 50 programs worldwide that were either directly addressing land tenure and property rights work, or in the context of other programs, governance programs, economic growth programs, etc., were touching upon land tenure and property rights issues. So this is an area that USAID is recognized as having intellectual leadership around the world. And it's an area where we've been working for a great number of years. And we've had a number of significant successes. If there was time, I could share with you some remarkable successes where we've been able to impact people's property rights in ways that have given them access to assets and reduced conflict and vulnerability. And in some very interesting and very real ways affected the rights of women, that has reduced their vulnerability and improved their ability to generate household income. We do collaborate with organizations. This was part of your question as well. We collaborate with other bilateral organizations, such as DFID or GTZ. We collaborate with a number of multilateral organizations as well, the UN agencies, the World Bank, the African Development Bank, the Asian Development Bank, etc., in a number of our programs around the world. And finally, I would say that within USAID, there is the Natural Resource Management Office, which includes a team that focuses specifically on land-related issues. And then there is this expertise within that team, where we have invested a substantial amount of resources over the last several years to develop tools and methodologies to assess, to better understand, to sequence, to implement programs related to land tenure and property rights, and then to go back and do analyses of what the impacts of those programs were. And all of those tools are available on a website, which I would be more than happy to share with you at the end of this presentation.
Can I ask a follow-up, because your comments raise a couple questions. One, I was struck by your figures about how the costs or what will be paid for in Sudan had the kind of 7-8 times greater than northern Uganda, and the challenge there. Bringing that back into the context of how you operate within a bilateral context, have you found creative ways to get past the bilateral strictures or working government to government, and where the land tenure and property rights may be a strategic objective and a primary focus of one USAID mission in one country and a lower priority or not a priority at all in another? And given that kind of statistic suggesting how interdependent these efforts need to be, have you found some creative ways to overcome the challenges of a bilateral organization? And then also ask you to talk more about, you alluded to a concern that the international community had about prioritizing moving people out of camps for food security concerns in ways that could be counterproductive for really addressing fundamental problems. Is there a broad failure in the international community to recognize these issues as challenges, or kind of a misprioritization that suggests that these immediate needs are overcoming the long-term, which would, of course, not be the first time. But if you could elaborate on some of those challenges and how within the donors and within the international community these issues are being discussed, so that some of the short-term doesn't yet, again, overwhelm, the inbox doesn't overwhelm the important. Let's see. Now I'm breaking my own rule and just expecting an answer to those questions. Why don't we take a couple more and give this to Hannah?
Thank you. This has been very interesting. I actually sort of had. My name's Hannah Fairbank. I'm in the Office of Natural Resources Management at USAID. My question is a little bit of a follow-up on Jeff's question as well. Do you all have interesting examples or cases where the resettlement of IDPs has been done in a way that has been well sequenced, with trying to get at some of those drivers, trying to address some of the land tenure and property rights issues prior or during the resettlement? And I see Greg shaking his head. And if the answer is, well, no, not really, are there characteristics of what a positive scenario would look like in your experience? Because this is obviously very challenging.
Terrific. Sean? Okay.
My name is Deborah Isser from the U.S. Institute of Peace. My question is, I wonder if you could comment on whether you feel that during a peace process, what role might there be for a peace mediator in trying to tackle some of these issues head on in the course of a peace process and actually incorporate some of them into a peace agreement, or whether these are sort of longer term issues that require a longer process? And I guess you also talked about the immediate post-conflict problems that can occur, and I wonder if there might be a way to try to deal with that in a peace agreement while one sets the stage for the more longer-term processes that occur. You talked about in Sudan, the CPA does deal with these issues somewhat, but I think it's also been criticized for kind of basically punting on the hard questions and leaving it to a land commission that has yet to be implemented, as you described. So I wonder, is that sort of a point at which one might try to tackle the issues more head-on?
Shall we take that basket of questions? And
sure. Let me start with the last first. I want to jump out of my chair and say absolutely yes. There should be a role, or there should be, in these post-conflict situations, a mediator who is both cognizant of these issues and also aware of different types of strategies which might be addressed, so that this becomes part of the peace negotiation. The problem is that these issues are often fundamental drivers, often in conflict, and it's sometimes they become almost sticking points in terms of how do you get around this issue if you want to bring people to the table and stop the fighting. So yes, it should be part of the negotiation process, but is it easily resolved, or is it easily addressed? In that context, I would say no, that it's particularly complex and complicated. Do you want to answer that?
Are you moving on?
I was moving on to one of the other questions. Go ahead.
Yeah, I'd like to give several concrete examples where I believe it has been. And I think there are 3 steps or 3 aspects that contribute to peace negotiations. And the first thing is discussing the starting point. What's the intellectual framework from which you are helping people go back home? What do they expect to really confront? And if the premise of that is I'm going to recognize that customary claims do have some relevance to the negotiations, then recognize it. Too often, government presupposes that they know what's best for their citizens, and in an effort to reestablish peace and to meet citizen needs, they presume that they know what is best. The second thing is to engage IDPs in actually the development of a roadmap. I believe that the reason that the CPA has not dealt with these issues, and the same reason that the Northern Uganda Peace Recovery and Development Plan is not addressing these issues, is nobody has sat with those people who are displaced and asked to develop a roadmap. I mentioned earlier in my presentation a large-scale workshop of traditional and civil leaders who came together. They can identify what the issues are. They know what they will encounter. And if they can agree on the mechanisms for dealing with disputes that they know will arise and recognize one another's authority in that process, then I think that's the second critical step in that process. And the final thing in terms of a peace negotiator, I think all too often it still boils down to an issue of who is getting what information with what frequency from what source. And establishing an honest broker as an information provider is critical in that process. If you do not have a trusted authority, body, or recognized set of individuals who are the sources of information, everything that you put out there, no matter how well-intentioned, will be viewed skeptically by those people who are desperate not to be manipulated anymore and desperate to go home. And they'll deal with the consequences of that, but it's really that just let me get home. So those are 3 important ingredients that I suggest are critical to the peace negotiation, the peace process, and recognizing tenure and property rights as either a source of that conflict or as a result of it.
Okay, with regard to the question on the trade-offs between the food security and the humanitarian assistance people, with the drive to get people out of camps as quickly as possible versus whether or not or at what point we start to address land tenure and property rights issues, I wouldn't necessarily say that it's a broad failure. What I would say is that there's a problem with understanding the differences in what people's needs are at different points or different times as they get ready to and do then indeed leave camps. I think that for many people, as the Northern Uganda case illustrates, many people will leave the camps and they will go someplace. They will either go to wherever they were last displaced from, or they will indeed go home, wherever that's defined. But it's for those people who don't have a clear trajectory, in many cases women or vulnerable groups, etc., it's not really clear where they're going to go. Pushing those people when they're not ready to go creates a very negative situation. And so not understanding their specific needs at that point in time is what I find to be particularly problematic. And so I think maybe perhaps having a better nuanced understanding of the needs of people in camps at X versus Y time would help us to probably better address this difference in understanding and the push or the question whether to push or not to push people out of camps as quickly as possible. I would like to say something about this bilateral collaboration, bilateral versus multilateral collaboration. And if I could just step out of the cases that we've used today, so far we've talked about Northern Uganda, Southern Sudan, and Kenya. If I could just say something about Rwanda or even more specifically Ethiopia, where we've had long-term ongoing land tenure reform programs. In the case of Ethiopia, we have had very remarkable success with bilateral and multilateral collaboration and cooperation that has led to, I think, some very remarkable changes in the way people access resources in Ethiopia and how they're able to secure rights to those resources through something that's called the Land Certification Scheme. This is something that USAID did in collaboration initially with Swedish SIDA in Ethiopia. And USAID has taken really the intellectual leadership in this program over the last 3 years, developed processes and procedures for people to be able to certify and secure their land rights for both men and women. And it has been a remarkable success. So much so now that when I visit Ethiopia, I have national government officials and local government officials saying to me, you the donors, have to come to us and find a way to help us scale up this program so that everybody in Ethiopia can have a land certificate to secure their property rights. And this is a remarkable difference because 5 years ago, basically, the federal government was telling us that they didn't think that this was necessary. And now there's been a significant embracing of this program. And so much so that other donors are coming to us now. The EU and other bilateral partners are saying, we would like to replicate your program. We like your model, we like your process, we like your procedure, we like the impacts. We would like to use your tools here in Ethiopia to replicate this program and take it nationally across the country. So I think in every way, that experience in Ethiopia has been a remarkable and very fruitful success. Want to answer that? No? Okay.
Great. Some other questions? Cynthia?
Hi, I'm Cynthia Brady, also with USAID in the Office of Conflict Management and Mitigation. And I have a two-part question. My first question relates to the challenges that are certainly in the cases of Uganda, Kenya, and Sudan, which you have alluded to. The land issues are not only in the conflict-affected areas, but they're national issues in lots of ways, and they're failures of policy, as well as failures of implementation and enforcement in lots of ways. So when you are looking at points of intervention for land reform that will help mitigate post-conflict conflict, either in the connection of peace agreements or PRDP-type interventions. Do you have examples of where that has been done successfully and targeted the specific conflict context and not inflamed grievances elsewhere in the country? Or do you have recommendations for how one could do that? I'm particularly conscious of the Uganda case and the fact that Peter, you laid out very nicely the set of challenges in northern Uganda around land. And at the same time, everyone says, well, in fact, land issues are probably more volatile in the south than they are in the north, a place like Uganda. Mm-hmm. So for a donor trying to tackle land challenges in that conflict context, one has to be very conscientious about the larger national issues. The second question is probably more for Gregory. I'm curious in the context of Kenya, where at this point, given the challenges of finding a political resolution, where are the points of entry on land reform? Do you see opportunities for outsiders to be useful, and at what level? Thanks.
Thank you, Cynthia. May I charge in, or
yes,
do you want
please.
to gather more?
No, go for it.
Okay. Successful examples of where we've engaged in land and property rights reform. I think, in my experience, the best examples, again, are driven in large part by areas of higher population density, where land is already recognized as a fundamental issue in national growth and development strategies. Hence, that insidious little... The death of 1,000 cuts, as we experience right now in Rwanda over land conflicts, the death of 1,000 cuts, as we're experiencing in southern Uganda, as people struggle over smaller and smaller parcels of land and deal with complex arrangements over leasehold, freehold, and basically an old feudal system that has been constitutionalized there. I'm going to speak, and it's not in deference solely to a USAID portfolio here, but I think that USAID has recognized in the Rwanda context the desperate need to involve itself in policy, legislative development that recognizes this complex set of issues in a country with an increasingly small resource base, and in helping people define land rights and their roles and responsibilities relative to decreasing land plot size. And so I believe that USAID is demonstrating an important set of activities there that actually start to illustrate the ways in which 4 major components can be dealt with simultaneously. One is the policy environment. 2 is the fact that a lot of people who are victims of increasingly smaller plot size are women and women-headed households and women in polygamous situations in a post-war situation. The third one is supporting traditional processes of conflict and dispute resolution over these plots. And the fourth one is a public information and awareness component. The big challenge that USAID is struggling alongside the government of Rwanda with is looking at how to get people to amalgamate land holding so that agricultural production can actually grow up, literally, and support a more vital economy there. I think that aid is struggling with exactly those same issues in southern Uganda. And by way of example, I would say probably some of the more vital investments have been in the post-conflict situation in the Balkans, where USAID has part of its graduation agenda there looked at the 4 elements that contribute to a post-conflict resolution setting, and that's been governance, that's been rule of law, that's been economic development, and that's been some sort of NGO capacity building agenda in those contexts. Those same sets of ingredients seem to be vital in that same portfolio to these situations and where we see land and now more broadly natural resource and property rights issues in densely populated countries as being fairly critical combinations. And unfortunately right now we're plagued by declining resources to support this. And I think that's the most fundamental challenge that we face right now in that context. Otherwise, I think there's some important initiatives there. Those areas that you suggest as being wide open, people going back home, there seems to be ample land. I think the stressors that we'll find in those situations are actually going to be more driven by subsurface mineral rights and access, particularly in Africa, as the world gets hungrier for those resources, as we mentioned at the outset. And the second thing is that, despite the intellectual argument of climate change, more and more people in that belt, in that Sahelian belt, and in areas of marginal livelihoods are going to look more and more for retiring back to a system that allowed them a great deal more flexibility to go to places that they can no longer go and have access to resources that they can no longer have access to. And I think that's fueling important conflict areas, particularly in the Eastern African region, between Kenya, Ethiopia, and Somalia. In the corner in the Moyale Triangle there, the same thing is characterizing southern Sudan and northern Uganda. The same thing is characterizing the eastern boundary of the Democratic Republic of the Congo and the Great Lakes states. So I realize it's a long-winded and not a very direct response, but I do think that there are some good examples, and I hope I've been able to identify a few of them.
I think the point of that, though, is that there are pieces in different experiences that perhaps eventually if we could bring some of those pieces together in one specific country, we might have a better experience altogether. The specific question you asked about, Cynthia, with regard to Kenya, is a sequencing question. What do you do first and then second and then third and then fourth, et cetera? Realizing that Kenya is a little bit different than the other two cases that we talked about because you don't have quite as many people who were displaced and nearly as many people who were killed, obviously. but you also have functioning markets and institutions to a greater respect than you do in those other countries. Having said that, though, I think one of the things that you start with is a public dialogue, a public discussion. It's already going on, but it needs to continue. And the government needs to telegraph to people that it's going to address the land tenure and property rights issue in Kenya. For so long now, every time when one of these issues has erupted, the government has relatively successfully swept it under the carpet. And it's been business as usual. But after each subsequent election, it's become more and more violent and more problematic, suggesting to me that the next eruption could be quite dramatic or quite violent. So I think the government needs to telegraph to people that it is indeed going to do something about this issue. And it needs to tell them, it needs to give them an idea of what that something is. Because I think you have to start to wind down or unwind some of the tension around this issue. When people think the government isn't going to do anything about it, people become more aggravated and more tense and more upset and more likely to explode. So if you can't begin to telegraph to people that, yes, indeed, something is happening around this issue, I don't think there's a way to begin the process of resolving or mitigating this specific issue. The second thing that you do is you have to absolutely come up with a methodology to address the displaced population issue, the IDP issue. As I mentioned earlier, some people will go home, but a lot of people don't exactly know what they'll do. And in some cases, people were telling us, look, this is the second or the third time that I've been displaced after an election. And I don't want to go back to this area where there was a resettlement scheme. I don't want to go there because my house will be burned down again, my property will be seized or taken. And I've worked several years to be able to gain assets. So where do I go? And so the question people are asking, who will be resettled? Under what circumstances? Where? And then where will those people actually go? On what land will they be resettled on? All of those questions need to be worked out in a very transparent methodology that people will buy into. And that discussion is not taking place yet. And that discussion, it's starting, but USAID and a couple of other donors are trying to get it on the table. But that discussion has to happen. The third thing that needs to happen is that there needs to be a movement on the Ndungu Commission report to address illegal and irregular land grants or land grabbing. If the government would just say, yes, we're going to implement the recommendations of the Ndungu Commission, if the government would just say that, I think that would really dramatically address some people's fears and would be a very large step forward in beginning the process of healing in Kenya and moving forward with addressing land tenure and property rights issues. The fourth, I think I'm on the fourth recommendation, before all of this happened, which I didn't mention in my earlier presentation, is the government of Kenya had started to develop a new draft land policy, which I won't go into the details of the policy. It would take another hour, and I won't do that to you. But this draft land policy has a number of provisions that are problematic and a number of provisions that are very good, and the government needs to move forward with considering issues that the recent crisis raised in light of the draft land policy, and then it needs to move forward with adopting the land policy. And then finally, we as experts or as via technical assistance through donor organizations, etc., need to work with Kenyans. Kenyans already understand the issue. They're very smart. They're very articulate. They have their head around this issue. In many ways, we can't provide a whole lot greater intellectual detail than Kenyans already know themselves. But we can work with Kenyans to help to provide assistance to what is called the Land Reform Transformation Unit within the Ministry of Lands. And they have a whole set of agendas. They have an agenda with specific issues. Some of them are short-term and some of them are more long-term. And they require technical assistance to move forward with their program and their agenda. When we left Kenya, when I left Kenya 9 days ago, a week ago, the government of Kenya said very specifically in an open discussion with about 70 people representing government, donors, multilateral, bilateral organizations, NGOs, civil society, church groups, etc. The government said very openly, we really appreciate this discussion that we had over the last 2 days about how the crises, how land tenure property rights had affected the crises, and what the next steps might possibly be that were recommended to them, not just by USAID, but NGOs, civil society, the private sector, investors, etc., that were sitting in that room over a 2-day period. And the government was really energized about where they would go, what their next steps would be, and how they would move forward. This is a very, very positive step, and I would encourage my own organization, USAID, but I would also encourage other organizations working in Kenya to seize this opportunity, to move forward and to embrace the government's offer to work collaboratively on this issue, because it creates a very unique window of opportunity in Kenya that hasn't existed before.
As if the conflict or the post-conflict setting is not kind of crisis enough to produce action, the rising attention to much higher food prices and the kind of resulting social unrest that rightly or wrongly is being attributed to changing in prices in sub-Saharan Africa but other parts of the world. Is this something that you see as an additional pressure to get governments and folks to take these issues seriously, or is this just going to be additional pressure for cheap and quick, counterproductive, or humanitarian fixes? Not to suggest that all humanitarian are cheap and quick and counterproductive, but short versus long-term perspective. Is that?
Yes, it's clear. Yes, and I think this will be a huge pressure on the land tenure and property rights regimes in Africa where we are currently working. My concern is that what will happen is that there will be a jump to take the least, what will maybe determine as the least path of resistance, and that could be a move toward a quick and dirty formalization of people's land tenure and property rights, without looking at the internal, customary, traditional dynamic that's playing itself out, and having a very nuanced understanding of the types of rights that people have and how those rights create different challenges and opportunities. And if you ignore or exclude those different rights, those different opportunities and challenges, you could potentially create situations where you undermine investment, you undermine agricultural productivity. You could actually go in the opposite direction where you need to go, and ultimately erode the resource base and generate conflict between groups. So I would say that yes, this is an extreme point of pressure, and the way in which we address this pressure will be critical to either a positive or a very negative outcome.
Terrific. Well, we've come to the end of our time. I think you've given us a very rich presentation, but also shown us that there's so much more there that we need to appreciate and understand as in our variety of capacities take on these issues. I urge everyone to share the insights from this meeting with colleagues and point them to the Wilson Center website for further, well, for watching the video and for getting a summary, and then also some resources that we hope you will help us connect everyone with. So please join me in thanking Greg and Peter for excellent presentation, hopefully. With some additional questions, why don't we because unfortunately,
this is very important. Everybody should know.
but please come up and we have follow-on conversations because we have to break for time. But why don't
meeting is after 2.
Yeah, but why don't we follow on those conversations one-on-one? Thanks so much for coming, folks.
Yeah, we can. It's okay. Hello.
I'll be right back. Just going to run.
I'm doing okay. Thank you. I had a scary situation, and I didn't want to